The most quintessential threat in the entire American lexicon is this is a nice restaurant. It would be a shame if anything happened to it. And because those words come from someone wielding enormous power, those words are different from if I say them over dessert. And I think courts have to recognize that when government officials that wield enormous power say things like that, because I think you're right, Nico. People don't practice what they preach. People are perfectly happy to spout free speech principles and then silence speech they don't like. And honestly, I couldn't promise you that I wouldn't do that. I believe in free speech. I'm a principled person. And if you gave me infinite power, I would probably punish people who said mean things about my mother because she's a nice lady. That's why we have constitutional principles, because you have to have background rules that restrain the natural human impulse to silence people who are saying things that outrage you.
Lord Acton meets Spider-Man.
Freedom of speech.
Fundamental rights.
Freedom of conscience.
Academic freedom.
Freedom of press.
And the right to listen.
You're listening to So to Speak, the free speech podcast, brought to you by FIRE, the Foundation for Individual Rights and Expression. All right, folks, welcome back to So to Speak, the free speech podcast, where every other week we take an uncensored look at the world of free expression through personal stories and candid conversations. Today, we are reviewing the 2024 Supreme Court term, looking at the First Amendment cases. Yesterday, we got NetChoice handed down from the court in a 9-0 decision. Joining us to discuss these cases are Robert McNamara, who is the Deputy Litigation Director for the Institute for Justice. Bob, welcome onto the show.
Thanks for having me.
To his right, we have Ronnie London, who is FIRE's General Counsel. Our listeners should be well acquainted with him. Ronnie, welcome back onto the show.
Thanks for it, Nico.
And then to his right, we have Bob Corn-Revere, who is FIRE's Chief Counsel. Bob, welcome back onto the show.
Always happy to be here, Nico.
So we're going to try and take this in reverse chronological order with one exception, and our listeners will get that soon, because we've discussed some of these cases back on past podcasts, but we haven't discussed, for example, the NetChoice case. We haven't discussed Murthy. We haven't discussed Gonzales v. Trevino. There's some cases we need to get to, and I'm going to try and front load them. And then we will get back to some of the cases that were decided earlier in the term. I want to remind folks that we are recording this 24 hours after NetChoice came down. So we are still digesting the opinion, and hopefully during this conversation we can think aloud about its implications. And also, this coming Monday, July 8th, we will have a live webinar for FIRE's members to participate and ask questions of their own about this past Supreme Court term. Ronnie, I think you're participating in that. We also have Will Creeley, FIRE's litigation director and legal director, and Darpana Sheth, FIRE's vice president of litigation. So without further ado, let's move on to the NetChoice cases. We have two cases here, one stemming from a law in Florida, one stemming from a law in Texas. One decision from the court. It was 9-0 with some somewhat testy concurrences. They dismissed the cases, or they remanded them, vacated and remanded the cases because they say that these lower courts did not review the laws properly as facial challenges. Bob, I want to start with you. What is a facial challenge, and why did the courts say that these lower courts didn't look at them properly?
Well, a facial challenge is one that challenges the law basically on its own terms and asks the court to conclude that it is unconstitutional either in all of its applications or in the First Amendment context in too many applications that would violate expressive rights. And so the court has permitted these kinds of challenges to go forward for many decades, but it is not the favored approach by the court. And that's one of the things that all of the justices in the NetChoice decisions made clear, except the majority, the 6 justices who sort of formed the core of the opinion, basically said, it might not be favored, but here's the process that you would use for doing a facial challenge. Sets a fairly high bar for that, but nonetheless says that in this context, particularly in a First Amendment context, you can bring these challenges. And it sent the case back to the 11th and 5th circuits to do a do-over.
To assess them properly. So again, yes. A facial challenge is just kind of a challenge to the law.
You're challenging the law as a whole.
So it's not, for example, how the law was applied in a specific circumstance to, say, Meta or I was about to say Instagram, but Instagram is owned by Meta, or X, for example, or
That's right.
TikTok.
That's
or would apply to a certain subset of applications.
So the courts sent these down, but in the majority decision, you get a lot of kind of stirring language about how these courts, the Fifth Circuit and what was it, the 11th Circuit, should analyze this case from a First Amendment perspective.
Well, that's right. I mean, the court, while it didn't decide the ultimate First Amendment issues and didn't decide whether or not these laws are constitutional, it did a serious course correction, particularly for the Fifth Circuit, to make clear that when the courts do look at these issues anew, that they do so under a clear set of governing First Amendment principles. And so it made a number of things quite clear, so clear that even the Fifth Circuit can't get it wrong the next time around. And so they include things like the First Amendment applies to new communications technologies. That is the rule, even in the case in the where you have advancing technology and you have new and novel applications. Made it quite clear that it applies to social media. It also made clear that when social media is making editorial choices, moderation choices, where they decide what information to post or not to post or to downgrade, that those are editorial choices, and editorial choices are protected by the First Amendment. And it also made clear that something that the Fifth Circuit got completely wrong the first time around is that the First Amendment's protection of speech applies to government actors, not to private actors. The Fifth Circuit had concluded that the moderation choices by social media platforms were censorship in the same sense, really, as censorship by the government. And Justice Kagan's majority opinion made clear that no, that gets it completely backwards, and that when the court goes to reconsider these issues the next time around, it has to apply these First Amendment principles articulated by the majority.
And those principles, I think, they're right, and it's nice to see the court articulate them. But kind of NetChoice itself, I don't think really accomplishes very much. And I think in part it doesn't accomplish things because both sides of the verses have kind of behaved in ways that made it hard for the court to resolve the case. I mean, the first is just the statutes that are being challenged are kind of a mess. Like what actually happened is legislators in Texas and Florida were mad at Twitter for what they viewed as censoring conservative voices. And so they tried to pass a law stopping Twitter from doing that. But the problem with legislating when you're extremely grumpy is you don't do a very good job of defining what you're trying to legislate against.
Well, it's not just when legislators are grumpy.
The problem with legislating, Bob, this is why legislatures shouldn't do things. But no, it kind of emerged at oral argument in this case that like everyone's talking about this as a regulation of Twitter and Facebook, but like by its terms, these statutes seem to regulate Etsy. How does this apply to Etsy? And the statute is such a mess, it makes it hard to do the sort of facial analysis that Bob was talking about.
But that's more true of the Florida law than it is of the Texas law. The Texas law focused on social media platforms of a certain size. The Florida law applied to internet platforms that could include pretty much anything. And that's the issue that really did emerge and dominated the oral argument in the case. And my concern with this is that the court's decision sending it back and saying you have to have a thorough analysis of what the statute does is it tends to reward legislatures for this broad and sloppy legislation. If they pass a law that says the state gets to regulate everything on the internet, then that places the burden on would-be plaintiffs to say, okay, let's look at the entire universe of things that this law can lawfully do and compare it to those things that regulate speech that the First Amendment prohibits the government from doing. And that's a real burden for the plaintiffs where really the root problem is sloppiness by legislatures.
Or it, puts the burden on the plaintiff to challenge the part of the law that it cares about. I mean, that's what I found a little bit, well, I don't want to say silly, about this whole thing, but the chiding of NetChoice for the way that they brought this case and for the way the parties and the courts addressed it below. Look, we all know what the legislatures cared about and what the folks who were upset about being censored on Twitter or on any other social media platform cared about. They cared about the parts of the platform where there's moderation. Nobody's complaining about, hey, I can't get Gmail because of my political views. That's not happening. You don't see news stories about it. Everyone knew what this case was about. and they litigated it accordingly. And so to get up to the Supreme Court and say, well, look how broad this Florida statute is. You really have to do a much more complicated legitimate sweep of the legislation analysis before we can even think about a preliminary injunction. All seems like a bit much. I'm glad they said, free speech reinforcing things in their balance of the decision. But I do wonder what's going to happen when it goes back.
And Bob helpfully clarified the Texas law, which essentially prohibits social media companies from engaging in viewpoint discrimination. And you can get some silly outcomes from that, right? If you ban speech supportive of Al-Qaeda, you also have to ban speech that would be in opposition to Al-Qaeda, right? You just get silly.
No. You can't do either one of those things. Let's be clear. You can't discriminate based on viewpoint, which means you can't pick a topic and say this topic is off limits. You have to allow things like, for example, we know that being hateful or being scandalous or being immoral are all viewpoints that are protected by the First Amendment. We know that from Tam and Brunetti from a few terms back. So you can't just kind of wholesale say this type of speech is off and claim to be viewpoint neutral.
Although they tried, right, by saying we could bunch it into categories and we would ban speech by categories, right?
This was the Texas Solicitor General's kind of saving construction of the Texas law was, whoa. We're not saying you have to host pro-Al-Qaeda speech. You just have to ban the category. You have to say there will be no speech about Al-Qaeda. And I have no idea why he thought that was better. But that was, in fact, his defense of the law.
Well, that's not viewpoint discriminatory at all then. Problem solved.
That was one of the answers that you're forced into at oral argument when you're trying to defend bad legislation.
And in Florida, you have a slightly different piece of legislation. As you say, it's a little bit broader in that it applies to internet platforms, but it's more narrowly focused in that it also only applies to how these internet platforms treat publications, news publications, political candidates, for example.
Exactly.
So
it's both more broadly focused and more narrowly focused. It's
with content-based preferences thrown into boot.
Yeah, exactly.
So a couple of lines from the majority opinion. On the spectrum of dangers to free expression, there are few greater than allowing the government to change the speech of private actors in order to achieve its own conception of speech nirvana. And this speaks to the animus behind the Texas and the Florida laws insofar as they didn't like how these platforms were moderating content, and therefore they tried to change the balance of what users could see on the platform.
Well, it also speaks to how the Fifth Circuit erred in trying to paint as censorship in the same sense as state censorship decisions by social media platforms. What the court was saying is that this is really a problem that the First Amendment speaks to government action and not to private action. And correcting that sort of load-bearing premise of the Fifth Circuit decision really, I think, goes a long way. And Bob, that's the one point I disagree with you on. I think this does a lot for future cases in terms of laying out the ground rules, setting the baseline constitutional principles that are going to apply so that, as I mentioned before, even the Fifth Circuit can get it.
Oh, no, it is. It's nice to see those basic principles reaffirmed, and I am glad to have sort of a left-right coalition firmly saying that the government can't regulate the marketplace of ideas in order to make it more fair, and recognizing that that is the most dangerous justification for speech. Because I think all of us realize that the marketplace for ideas is unfair, because if it were fair, our ideas would have won by now. And so obviously it's biased against us, and kind of recognizing the dangerousness of that idea, which has had a lot of currency on the left and a lot of currency on the right, and to have it rejected in that kind of ideological coalition, I think is gratifying and is great to see.
Well, yeah, but if you look at the concurrence from, what was it, Alito or Thomas, they say that all the kind of First Amendment analysis that's provided in Kagan's majority opinion is dicta, right? So what can we take from it?
Well, in a sense, it is dicta in that it's not a binding ruling, except for the fact that you have a majority of the court saying this is what the First Amendment requires. And so while the court, I suppose, when this case eventually comes back, as it inevitably will, could say, sorry, we didn't mean it. That's not going to happen. You now have a majority of the court, a solid majority of the court, and as Bob says, a bipartisan or multi-partisan coalition of justices making these points. So I think that is going to set the baseline going forward, even if it isn't a precedent as in, say, striking down a particular law.
Well, here's a minority view. I don't think it is dicta. I think it is necessary to the outcome of the case because in order to say this was a facial challenge and you did not conduct the analysis appropriately, you have to discard some of the other challenges. For example, I have always worried throughout this case that somebody would wise up and go, this stuff's preempted by Section 230. Why are we dicking around with reaching the constitutional question? Now, there's a footnote in the decision that explains.
Is dicking around a technical term?
Well, that's the technical term.
We've got a lay audience on this podcast.
There's a
right?
Latin phrase for that.
That's right. That's right.
Yeah, in any event, there's a footnote to that explaining why that was not advanced below. The court below didn't pick in the 11th Circuit didn't pick it up. But that was always a potential outcome if you really wanted to dodge, not just dodge a little like they did here. But the other issue in this case is a compelled speech issue. And compelled speech doesn't use the same analysis as a facial challenge. Compelled speech is basically, if you look back, for example, at 303 Creative and the cases that it cites, what becomes clear is compelled speech is unconstitutional pretty much full stop. If you go back through the court's compelled speech cases, you don't see them applying strict scrutiny. You see them saying compelling speech is unconstitutional. Now, in order to have the facial challenge and the failure to conduct it properly be the grounds on which this decision is rendered and sending it back, you have to ignore the compelled speech aspect of it. In order to do that, you have to have this explanation of what rules would apply and should have applied if you had conducted the analysis properly. I know I'm going out on a limb a little bit here by calling it necessary to decision, but I don't think it's so obviously dicta that they could simply walk away from it when the case comes back up.
BCR?
I think it's dicta plus. I think it is the court expressing what it believes the law to be, and as I said before, a majority of the court. You can argue over whether or not it was absolutely necessary to the decision. Ultimately, the court's analysis of what is required for a facial challenge was sufficient to make a decision and send it back, and to say that the lower courts hadn't performed that necessary analysis. But and the court was clear about this, saying we need to lay out the First Amendment principles so that the lower courts don't screw it up the next time, and called out the Fifth Circuit 3 different times in the opinion to drive that point home. So, I would say it's more than dicta, maybe less than a rule of decision, but nonetheless, I think it's going to guide lower courts going forward.
Well, the majority says that the Fifth Circuit decision rested on a serious misunderstanding of First Amendment precedent and principle, but I'm not sure that Alito and Thomas are as convinced, because they give credence to the common carrier argument that they say the majority decision just didn't grapple with, but they should have.
They do. They're a minority of justices that take a different view. And this is something else that I think underscores a lot of, the problem with court viewers. And that is, here you have a 9-0 decision, no dissents, and yet it's in effect a 6-3 or 5.5-3, 3.5 decision. Setting out what rules should apply to these cases. It also belies the usual, political reporting that you'll get about the court, saying it's this conservative supermajority of 6 justices. Well, that's just not the case in the First Amendment context. You see justices joining forces across ideological lines quite a bit based on the First Amendment principles that we all hope that the court will uphold.
Well, do you guys think the common carrier argument carries any water?
So I think it's very difficult to make the common carrier argument for social media companies because part of sort of inherent in being a common carrier is the notion of some kind of quasi-monopoly. That you're a must carry because you have this route, you have this power line, and you're some kind of technical monopoly. That's the basis for common carrier regulation.
Well, and usually a government-granted monopoly. And for justices that rely so heavily on history and tradition, like Justice Thomas and Justice Alito, to then claim that social media companies are common carriers is nonsense.
And so common carriers, what you're saying there, Bob, is they're like the phone companies, they're like water, to the extent there are private water utilities or electrical companies.
A railroad is the classic example. You build a railroad line, no one's going to build a railroad line next to yours. And so you have essentially a monopoly over the two cities that you've built your railroad line between, and that comes with certain regulatory obligations not to deny people service on your railroad line.
Right.
Yeah, well, the other distinguishing feature of a common carrier is the offering of non-discriminatory service. And here you have the mirror image of that, right? Everyone's up in arms because the service is being delivered on a discriminatory basis based on which viewpoints or what types of substance the social media platforms want to carry. It's a little bit ironic to say, okay, wait, that's a problem. Let's make them common carriers.
But not only that, if you go back historically to the origin of the common carrier doctrine, whether you're talking about railroads or stagecoaches or waterways, those things were adopted in the communications world only by analogy. When the Radio Act of 27 and the Communications Act of 1934 were adopted, they basically were saying, why don't we just borrow that concept of common carriage from the transportation world and we'll apply it? But it applied only to specific phone service, point-to-point communication between people where the company had nothing to do with that communication. It didn't apply to radio or ultimately to television or other communications media. And here you have a new medium that has never been subject to these kinds of rules and has never played by this non-discriminatory access that Ronnie was talking about. And so to simply say, poof, you're a common carrier because we want to impose obligations on you is contrary to history and is contrary to the traditions of the First Amendment.
And I also think it belies a lack of imagination about how the world works. Like, people invent things. The world is dynamic. And, right now, you could say Twitter has a monopoly on Twitter. But there's no obstacle, and as we've seen, people do start new social media companies.
They leave social media companies when they become dissatisfied with the new owner.
Exactly. The marketplace seems to be operating.
Well, the argument I think on the other side would be we saw what happened with Donald Trump after January 6th. All these social media companies dumped him. But then the counter-argument to that, of course, is you had platforms like Parler and True Social that started up.
He was never heard from again.
Justice Barrett also has a somewhat interesting concurrence in which she speculates that maybe these principles that underlie the First Amendment that the majority opinion says don't change with the advent of new technologies, maybe they will change with artificial intelligence. Did you all see that?
Well, she did try and draw some nuanced distinctions between direct editorial choices made on the part of platforms or where they use algorithms to simply implement the user's changes or use artificial intelligence to make those kinds of things. But she simply raised that as a question, which I think is appropriate in a matter where the court is not deciding the ultimate questions, but saying that this is a complex and nuanced area and we need to take some care in analyzing the facts before we make a pronouncement one way or the other. I'm not wild about the idea that she left it open that even machine-based editorial choices or particularly machine-based editorial choices might change the balance because ultimately it is the platform that is programming those algorithms to make those choices.
At least until the singularity.
That's right.
Well, to level set, I think what Texas and Florida were seeking to address with their laws were human-centric moderation decisions to deplatform.
I don't think they distinguished.
Yeah. No, I don't think they did distinguish, but I think the animus for the laws came from the deplatforming of former President Trump.
Who knows what goes on inside the minds of legislators?
From the New York Post story and the Hunter Biden laptop issue. But most platforms' moderation decisions happen algorithmically.
They have to.
They have to. You have millions of pieces of content that need to be sorted through and can't be sorted through by simply humans. And then she has this question like, but what if a platform's algorithm just presents automatically to each user whatever the algorithm thinks the user will like?
Well, that's still a choice.
It's still a choice, but it's also like how most algorithms work.
Right.
They see what you engage with, they see what you look at, and then they tweak the feed to present you content that you think will be more engaging.
That's one of the things that they do. I mean, what the legislatures were really concerned about is the fact that these platforms have terms of service where they define what kinds of communities they want to foster. They don't like certain kinds of speech. They don't like hate speech, and again, I'm generalizing, or misinformation, or various kinds of things that are supposed to be forbidden on those platforms. Now, a lot of times these rules are enforced more in the breach than in the observance. It's hard when you've got billions of posts coming in all of the time, or in the case of YouTube, 500 hours of new content every minute.
Well, 500 million, I hope.
Huh?
500 million.
No, 500 hours per minute.
Per minute.
Per minute.
There's not 500 million.
Or was it per
hours of
day?
content.
Is that the daily figure? I thought I saw 500
No,
million.
We're just talking about big numbers at this
Yeah,
point.
yeah.
There's a lot of videos coming into YouTube.
Multiply 500 times 60 and then by 24. And then
Well,
you'll
obviously
get
I
your
can't do
number.
that math.
But then get an algorithm for that. But that's why you have to have these decisions made on that basis. Platforms can't live without it. And so whether or not you're having human moderation or algorithmically based moderation, that is a necessary function of the internet, and it is an editorial choice.
Well, what do you say then, Bob McNamara? That's going to constantly confuse me. I know Bob Corn-Revere told me to call him Bob BCR, but I've just never called you that.
Should we do good Bob and evil Bob?
We'll let the listener decide which one is good Bob and which one is evil Bob. But I host a free speech podcast. I've been doing it for 7 years. It's hard to believe now. The most common response I get from our listeners is about the censorship that they most often experience in their day-to-day life, the censorship they experience on social media. Now, you can call that censorship. I know we take issue with calling it censorship because it's a private actor determining who can and cannot be on their platform, but that's how they experience this world where they put out an idea and someone is trying to stop that idea from circulating or stop them from sharing that idea. What do we say to those folks who are concerned that this is the most significant censorship issue of our time?
I mean, in a way, they're not wrong. And it is frustrating when there is a large venue for communication and you can't make your voice heard in it. I have personally been censored by the New York Times repeatedly. I've submitted op-eds and they have not published them. And that's terrible because they were great op-eds and they should have run them.
And there you've defined the problem. I mean, people simply don't have a right to be on a private purveyor of information, whether it's the New York Times or on a social media platform. And really it's a matter of coming down to which is the worse evil. And the majority opinion in NetChoice basically said that as bad as some of these marketplace-based decisions might be, in your estimation, putting the government in charge of it is worse.
Because the government will never get out of the business of being in charge of how fair the marketplace of ideas is. Where,
exactly.
As we've seen, companies do get out of that business because if people don't like the decisions they're making, if your voice is really strong, if your opinions are right, eventually there are places you can make your opinions heard, and that's what changes the culture and what changes the overall stream.
Or they
of
may
American
change
opinion.
their approach to it entirely,
Right.
as we've seen with Twitter and X. You might like it or hate it, but the fact is that was a response made based on the way in which the company had been operating previously.
Yeah, much like I've always said, people get the government they deserve. People get the social media they deserve. They get the social media they're willing to tolerate. They get the social media that presents the compromises that they're willing to accept. You don't have to be on social media. Trust me, I know. Whether you are willing to remain on a platform or any platform, if it's not serving your needs, that's entirely up to you. And like you said, the market ultimately will speak to user preferences if the users are willing to express them.
So what's going to happen from here? The case is going to go down to their respective circuits, and I don't see how you read the majority opinion and have really any movement to do anything other than to say these laws are unconstitutional, right?
What the courts have been instructed to do is to more fulsomely define what these statutes do, what applications present First Amendment problems and which ones don't, and whether or not the unconstitutional applications outweigh the potential constitutional applications. And, that's the methodology for a facial challenge in First Amendment context.
So how would that work in practice? They would look and they'd say, okay, yes, this law does apply to Etsy. Yes, this law does apply to Venmo. Yes, this law does apply to Uber, but it also applies to Meta's moderation decisions, TikTok's moderation decisions, and X's moderation decisions, and then they put it on a scale and figure out.
It's the unconstitutional applications have to be substantially more than the legitimate sweep. I mean,
looking at this opinion, that would be the one, the social media networks, the Metas, the TikToks, the X's. I mean, it's hard to read the opinion and not deem the law unconstitutional as applied to them. But then you look, okay.
Basically, it's the one that are doing the kind of moderation that the court describes as being protected by the First Amendment. All those functions would be in your numerator, arguably, and then everything else that the statutes ultimately sweep in. And it's different for Texas and Florida, as Bob said. Would be your denominator, and then yes, you do some kind of silly little math.
We're doing a lot of math here. Yeah.
I know, right? I went to law school to avoid that, but it's interesting because one of the things I was thinking about, last night as I lay awake in bed thinking about this, as I sometimes do, is I was worried about what becomes of the preliminary injunctions. And Bob and I talked about this a little bit this morning. If you look at the Supreme Court's decision, it's interesting what it does. It doesn't say the decisions below are vacated for proceedings not inconsistent with this decision. It says the 11th Circuit and the 5th Circuit decisions are vacated. What's the net effect of that? Well, that means you have a decision in the district court in Texas and a decision in the district court in Florida where preliminary injunctions have entered. And, I would argue that they therefore still remain in place pending next steps in litigation. And one way to go would be for the courts to go ahead and process these as facial challenges under the instructions and the framework set out by the court. There's nothing stopping the complaints from being amended or the challenges that are teased out of the complaints being modified. I mean, you could decide if you were a litigant to change your challenge from a facial challenge to an as applied to social media as described in this decision challenge. You don't have to do the facial facial analysis the court describes. Instead, you just then proceed to strict scrutiny.
This is where we're going to go out of order. If we were going in reverse chronological order, we would go next to Murthy v. Missouri, but I think it's probably better for the case, for the discussion of jawboning to start with NRA v. Vullo, which is the case involving the New York State regulator that put pressure on insurance companies to stop doing business with the National Rifle Association in the wake of the Parkland shooting. Essentially, Maria Vullo, state regulator there, had a meeting with some of these insurance companies. I think Lloyd's of London was one of them, where they essentially said, if you stop doing business with the NRA, giving them these insurance policies, then we won't investigate you for these other things, right? And this creates a burden on the NRA's expressive activity because the animus here was that the New York State didn't like the NRA, was pushing for gun control in the wake of the Parkland shooting. I might have described that wrong. I'll let you all correct me. But the long and the short of it, in the 9-0 decision from the Supreme Court, they said you can't do that. You can't coerce private entities to stop doing business with other private entities just because you don't like the speech of one of those private entities. Is that right? Is that your understanding of it, Ronnie? Yeah, well, they said you can't do that if that is in fact what you did. Don't forget the posture of this case, right? This case is up on a 12b6 motion on a preliminary injunction, and that means that in construing the complaint, you have to accept all the facts as true and all the inferences reasonably drawn from them in favor of the plaintiff. And the NRA alleged all of the things that you just described, including that Vullo is a regulator who has direct enforcement regulatory authority over the financial services and insurance companies that she oversees, and that she had these communications with them. And one thing that I didn't really appreciate until the Supreme Court decision, she talked about, among other things, reputational risks. And it wasn't until the Supreme Court, in a footnote in the case, explained that that's a regulatory term of art that can be determinative in potentially bringing enforcement actions or finding problematic something that a bank or financial service did. So when you say pay attention to your reputational harm, it's not just, hey, people out there might think bad things about you if you continue to do business with the NRA. It's actually a hook for regulatory action. And you add up all the various ways in which she leaned on the insurance companies and on the financial services companies and described as the NRA described it, it's pretty easy to see a coercive pattern there that, as you say, you can't do this.
Well, let's put this in I think, more direct terms. You have a state that regulates banks and insurance companies, and they use that financial regulation in ways to tilt the political debate over guns. It doesn't like the NRA. It knows the NRA has affinity insurance programs, and so it takes measures to enforce the law in ways that put pressure on the NRA. They go to the banks, they go to the insurance companies, and they say, if you don't sever your ties with the NRA, then bad regulatory things are likely to happen to you. Or if you do sever your ties, maybe we'll look the other way on a few other things. So you have the state using its regulatory power, threatening to use its regulatory power in ways that are going to affect political discussion. Okay, that's what the court was talking about. And by the way, in backing up and showing the ties to what we have here, as Ronnie pointed out, this was at a preliminary stage of the case. It's not after a trial, after the case has been determined. It's just looking at the complaint that the NRA filed and whether or not that stated a claim. And the court said that it did based on these principles. And similarly, what we have here in the NetChoice cases are you have principles being articulated by the court that are going to be applied in the lower courts going forward. So the same is true in both NRA and in this case. You have the Supreme Court setting the baseline for what the constitutional rule is, and it should lead to the right result when lower courts get done with it.
But going back to what Ronnie was saying earlier, if the state regulator has an interest in ensuring that there is no reputational harm by these insurance companies from doing business with certain other companies, and the NRA is a very controversial organization, particularly in the wake of school shootings, as we know, why don't they have an interest in saying you should watch out for your reputation in doing business with the NRA? Bob McNamara?
Well, I think that's exactly what they're not allowed to do. To the extent that the regulation encompasses doing business with ideologically unsavory people, that's just an unconstitutional regulation.
But then what does the reputational harm regulatory authority even mean there if you can't determine the reputation of the folks that you're regulating?
Well, so insurance companies and banks are the government's justly concerned about the reputations of insurance companies and banks because they're entities that we rely on to pay us money when we need money. When we go to make a withdrawal from the bank, when our house burns down, we go to the insurance company. They're supposed to have a reservoir of money. And if they act in a way that starts to make the market think, gosh, you guys aren't going to have a reservoir of money, I better pull all my money out of the bank. That's the asserted government interest there. It has nothing to do with, the people you're doing business with say mean things about me, the governor of the state. And that's kind of what New York was leveraging these regulations to do is say, people in New York really don't like the NRA. They're advocating for really bad stuff, and that's going to cause harm to your reputation. And if I find you have a bad reputation, which is supposed to be financial, but here I'm just making it ideological, I can actually shut down your ability to do business in New York State. That's what Bob's talking about in terms of leveraging the state power to cut off your political enemies from essential kind of private market services.
And what about this idea that the insurance program or the insurance policy that I believe Lloyd's of London offered and maybe one of the other insurers offered is illegal in New York State, often referred to pejoratively as a murder policy? So the insurer, you would be insured against a misuse of the gun, whether for murder or something else, I guess.
So I don't want to pretend to be an insurance lawyer because I've successfully avoided that my entire life. But ultimately, that doesn't matter because that was just the state's hook. If you speed on your way to work and the police pull you over and say, look, you were going 90 in a 45, that's super dangerous. And while I have you here, let's talk about this podcast of yours. It doesn't matter that you were driving too fast. The pressure about your podcast is what makes it unconstitutional.
That's right. And the court actually spoke to that point, saying that it may be that these affinity insurance policies are illegal. That's not the issue here. The issue here is whether or not the state is illegally leveraging its regulatory power on third parties to affect the NRA's speech.
So in Sotomayor's opinion here, she writes, a government official can share her views freely and criticize particular beliefs, and she can do so forcefully in the hopes of persuading others to follow her lead. In doing so, she can rely on the merits and force of her ideas, the strength of her convictions, and her ability to inspire others. What she cannot do, however, is use the power of the state to punish or suppress disfavored expression. But the line there isn't always clear, is it?
No, it's not. And that's always been the problem. This is a rule that goes back to 1963 in a case called Bantam Books versus Sullivan, where the Supreme Court established this doctrine that you can't use informal coercion to restrict speech in ways that you're barred from doing directly by law. And so the difficulty there is what informal measures fall into that category? How much does the government have to do to cross that line between persuasion and coercion? And up until now, the court has never really defined that. The innovation in NRA versus Vullo, or at least the advancement of the law in NRA versus Vullo, and Ronnie may disagree with me on this, is that the court at least articulated certain criteria that lower courts should use in analyzing when that line is crossed. Not a precise line. It is a very fact-bound kind of inquiry. You have to look at a range of factors. But nonetheless, the court not only reaffirmed this principle, but also tried to create some analytic tools for determining when speech goes too far by the government.
Yeah, I mean, it basically agreed that the things that the lower courts have been teasing out of Bantam books for decades are, in fact, appropriate criteria to look at. And I wouldn't go so far as to say not novel, but, you're not getting a patent for it.
And so then it sent it down to the lower court and said, you got to analyze it through this Bantam books framework that we are now more clearly articulating than we did in Bantam books.
Yeah, well, not only that, they basically reminded the Second Circuit how you read a complaint at the early stages of a case when it's faced with a motion to dismiss.
Well,
because one of the things we talked about in our amicus brief, I think it was in a footnote, was one of the things Second Circuit did was it basically disaggregated all of these like individual, death by 1,000 cuts, right? So here's this letter where they say, think about, your reputational risk. And over here's a conversation where they said, hey, well, if you get rid of these affinity programs, maybe we'll ignore a few of these other offenses.
And then a press release from the governor.
Right, and a press release. And you look at them all individually, and all individually, any one of them is fine. So therefore, this must be perfectly okay. And that never made sense to me. And the court makes very clear that you have to draw all the inferences and the potential connections between those in favor of the NRA at this stage in the litigation, and that's the appropriate test.
So you can't just look at the discrete interactions between the state regulator and the insurers. You have to look at them as a whole.
And how they'd be understood.
That's right. And what's
by the
interesting
regulated
is
entity.
The Second Circuit, when it upheld dismissing the complaint, articulated these very factors that the court has endorsed. It just misapplied them. And so the court basically said, yes, Bantam books means what we said it meant in 1963. And by the way, now apply these factors in a way that makes sense under the Constitution.
So the court here, Bob McNamara, said, in more or less no uncertain terms, it says it a little bit in the majority opinion, but I think it says it more directly in Gorsuch's concurrence, that this is well-settled law, right? What does that mean for qualified immunity?
So that's the next stage in Vullo, and it is, I think, one lesson of this Supreme Court term is if you care about the First Amendment in this country, you have to care about the state of constitutional remedies in this country. Because the Second Circuit said two things in this case. They said, look, this isn't unconstitutional coercion. All of this is cool. And even if it were, there would be qualified immunity. And so qualified immunity is this rule the Supreme Court has invented largely out of whole cloth that says a government official can't be held liable for violating the Constitution unless they violated a clearly established right, which means a right that some court has specifically held cannot be violated in exactly these circumstances. It is, depending on how you apply it, a tremendously difficult test because the world is complicated and the same thing never happens in the same way twice. And so what will happen on remand is the defendants in this case will say, look, we should be entitled to qualified immunity because this wasn't clearly established. And we know it wasn't clearly established because you guys, Second Circuit, didn't know we weren't allowed to do this. You thought it was fine. And that's going to be a tremendous obstacle in actually getting this case beyond the complaint stage because there is this huge barrier set up to any kind of constitutional liability, which, as we'll talk about even more when we talk about Murthy, it makes it very difficult to create any kind of disincentive for this sort of leaning on third parties to silence your political opponents.
Yeah, although what's interesting is that the Supreme Court did not take up the qualified immunity question when asked to do so after the Second Circuit decision, but then in issuing the decision that it did, saying we break no new ground, this is the law, has been the law since 1963.
The words well settled are used.
Yeah,
they're there on purpose.
Right, yeah, I think it's sending a pretty clear signal. In fact, the government tried to argue that by not taking the qualified immunity question, the Supreme Court had mooted its jurisdiction over the case, and they drop a very pointed footnote at the beginning of the decision saying, no, we didn't. And by the way, one of the reasons is the Second Circuit might want to reconsider that qualified immunity determination when this goes back.
Yeah.
So there's a few signals within the case that, while ordinarily you're absolutely right, Bob, that qualified immunity can be quite a high bar. Here, I think at least the court has given the plaintiffs a little bit to push back on that with.
No, the court has sent strong signals. I think the problem is those signals are coming back with you to the same court that decided this case before. And that always – sometimes you will find appellate courts chastened by the Supreme Court's intervention. And sometimes you will – you'll all remember Judge Reinhardt on the Ninth Circuit, who I think apocryphally was quoted as saying the Supreme Court can't catch them all. And sometimes appellate courts just try to see what they can get away with.
Is that a Pokemon reference?
I think that's absolutely true. But what you're seeing is the Supreme Court ramping up its signals to the lower courts saying, we really do mean this.
Well, and don't forget, the only reason this case was able to get to the Supreme Court was because the district court denied qualified immunity at the pleading stage. You can't get an appeal on a grant of qualified immunity. So it is going back to a district court that said we have to develop the facts here before we can decide qualified immunity to begin with.
Well, it's up on an interlocutory appeal, so I think the Second Circuit has jurisdiction to say that was wrong, there is qualified immunity. I think it oughtn't to say that. I think the Supreme Court has been pretty clear that we think this is a boring, easy case and we don't know what you're doing. But that's the next battleground.
But you have a concurrence from Justice Ketanji Brown Jackson who writes, the effect of Vullo's alleged coercion of regulated entities on the NRA speech is significantly more attenuated here than in Bantam Books or most decisions applying it. It is, for instance, far from obvious that Vullo's conduct toward regulated entities established, quote, a system of prior administrative restraints, close quote, against the NRA's expression.
And I think having listened to the oral argument in this case, I think to put it as gently as possible, Justice Jackson was not fully informed as to what Bantam Book stands for. I think she was taking it in a very literal sense to mean if you put pressure on bookstores because it involved books, that necessarily involves a protected expression and a First Amendment issue. But because here the pressure was on third parties that were insurance companies, then that doesn't necessarily raise a First Amendment issue. But the pressure was imposed on insurance companies to censor the political speech of the NRA. So for her to say that the direct link is more tenuous is, I think, really just to misunderstand the issue.
And you don't have to set up a series of prior restraints in order to have a Bantam Books problem.
That's right. It can be any restriction of speech.
Let's move now to the other jawboning case, Murthy v. Missouri. This is probably the more culture war-y issue or case of the term.
NRA was pretty culture war-y.
A little bit, but this case involved COVID, right? And I think to a certain extent maybe some election disinformation.
All of these cases we've been talking about involve litigating the culture war, whether it is the moderation policy of social media platforms, the NetChoice cases, or Murthy versus Missouri, where you're going after the Biden White House for putting informal pressure on social media platforms, or NRA. They are all attempts to politically manipulate the marketplace of ideas. And what you have is the Supreme Court, in most cases, Murthy is an exception, sorting out what First Amendment principles should apply.
So this is a 6-3 decision, and as you were referencing BCR, this involved federal government officials putting pressure on social media companies, predominantly during the COVID era, to censor what they saw as COVID myths or disinformation related to vaccines and other sort of restrictions that were put in place throughout society at that time. And ultimately what the court rules is that the plaintiffs in this case did not have standing to bring the challenge.
Right.
What does that mean? So they essentially just kind of sidestepped the issue completely?
It means they weren't able to demonstrate as a threshold matter whether or not the actions that they alleged were traced to a constitutional injury that they experienced, and that they couldn't point to ways in which a court action would redress their harms. And so that is a threshold question for whether courts have jurisdiction to hear the case in the first place, and the Supreme Court held that in this case that hadn't been demonstrated. Now, this is an example.
And the plaintiffs, hold on, are social media users, states?
Well, it reached that conclusion for all of them. It said that particularly for the states that were plaintiffs below, but it also said that for individuals, even though the majority acknowledged that at least one of the individuals had a better claim to standing than the others.
This is Jill Hines, I believe.
Right,
yeah.
But it just wasn't enough. This is an example of where I think culture warriors really shot themselves in the foot. This really was, I think, a pure culture war case going after the Biden administration, and hilariously having state attorneys general from red states being among the plaintiffs because they are some of the worst offenders when it comes to these kinds of jawboning activities. And
Or legislative.
well,
Look at NetChoice.
Yeah, well, same thing there too. And because of that, they used what we now know as the Twitter files as the basis for bringing the case of these background efforts by the administration, which, by the way, we think were unconstitutional. We at FIRE think were unconstitutional as well under the Bantam Books principle. But they started with that, brought this case, had lots of information about general efforts by the administration and really a lot of unseemly stuff about the administration trying to work hand in glove with social media companies. But they had a very compliant district court judge that basically uncritically accepted every allegation, and it really did read like a culture war centerpiece.
Okay. I want to read something from the decision. I want you guys to tell me, to the extent you think the court is wrong, why it's wrong here. Okay, so it says here, the plaintiffs fail, by and large, to link their past social media restrictions and the defendant's communications with the platform. That is, you have the users here who the court says do not link the taking down or the moderation of their posts to something the federal government coerced the social media companies into doing. Continues. In fact, the platforms acting independently had strengthened their pre-existing content moderation policies before the government defendants got involved. For instance, Facebook announced an expansion of its COVID-19 misinformation policies in early February 2021, before White House officials began communicating with the platform. And the platforms continued to exercise their independent judgment even after communications with the defendants began. For example, on several occasions, various platforms explained that White House officials had flagged content that did not violate company policy. Moreover, the platforms did not speak only with the defendants about content moderation. They also regularly consulted with outside experts. This evidence indicates that the platforms had independent incentives to moderate content and often exercised their own judgment. To be sure, the record reflects that the government defendants played a role in at least some of the platform's moderation choices, but the Fifth Circuit, by attributing every platform decision, at least in part, to the defendants, glossed over complexities in the evidence. So the court is just not seeing, like what we saw in NRA v. Vullo, where a very clear indication that it was the government action that resulted in the moderation
Exactly.
choices.
Easy to trace in NRA versus Vullo because you have statements by the Director of Financial Services leading to decisions by Lloyd's of London. You have a press release from the governor. Very easy to see. Here, where you have 1 million contacts between the administration at various levels and other private actors as well, and then decisions in gross made by social media platforms, all based on policies that they had independently, then it's really hard to trace, even though I think our position has been consistently that having government that involved in moderation decisions is not a good thing and can violate the First Amendment.
What if though, the platforms invite the government in?
Well, they can do that.
Volitionally? I mean,
Yeah.
that's always going to be the question, right?
Right.
So what you're going to have is you're going to have an allegation like you have, for example, in Vullo, that, they were cowed to let them in. Yeah, they said they were letting them in voluntarily, but truth of the matter is they were leaning on them. I mean, look, we've seen ads from certain social media companies that are basically asking for regulation. They're not doing that because, they really want to be regulated. They're doing it because they fear bad regulation and they're trying to welcome regulation that they could live with. So when you say voluntarily, that's a bit of a loaded term, and that becomes kind of a question of fact.
Bit of a shotgun wedding.
Well, and I think that's kind of where Vullo goes right, is to say you have to look at this in context. And in any interaction with the government, particularly an interaction between a large corporation and the federal government has enormous power. And there's always going to be a thumb on the scale in favor of compliance. But I also think the discussions in Murthy actually, I think, obscure a little bit how hard it actually would be to hold the federal government accountable here. Because for the most part, the opinions in the case are talking about what happened in the past. Like, have they really shown that this particular jawboning caused this post to be taken down? But that's actually not enough to let them sue. What they would have to be able to prove is not only that this happened in the past, but it's likely to happen in the future. Because all they're asking for, and there's a paragraph in the majority pointing this out, they're only asking for an injunction for forward-looking relief. And so it's not enough to prove the government silenced them in the past. They have to show, not only during the COVID era did they do this, but I actually have proof they're going to do this again to me next week or the week after. And the reason they're doing that is that the Supreme Court has said you cannot sue a federal official for violating your First Amendment rights and in the past.
That's why, the problem was the way in which this case was brought by a collection of users and by the states, because there it's very hard to prove what was in the mind of the social media companies when they made particular moderation decisions. But if the case had been brought by the platforms themselves, saying, here are all the contacts from the administration, here's what they told us to do, we didn't want to, but here are the changes we made to our moderation policies and they're still in place, then, based on the principles articulated both in Vullo and in Murthy, you would have standing, and you would have a colorable First Amendment claim.
Though the problem with that is you're never going to see that lawsuit. The insurance companies didn't sue Secretary Vullo because Secretary Vullo can destroy their business in New York.
Yes, but the social media platforms have been pushing back on state and federal laws.
Yeah, you could get Elon Musk under Twitter 2.0. All this censorship or alleged censorship happened under Twitter 1.0. Now you have Elon Musk. So, could Elon Musk now file a lawsuit for what happened in the past and enjoin it from happening in the future?
He cannot, because you can't get damages from a federal official for violating the First Amendment in the past. And so you have to prove that it will happen again. And the government's response is going to be, look, this was years – these people don't even work here anymore. Who's to say that we're going to jawbone you again? And it makes it almost impossible in a lot of practical scenarios to create any kind of government accountability. It's why I say if you care about free speech, you have to care about the law of remedies, because Elon Musk doesn't have one.
But what does he say? Hold on here, Ronnie. I want to respond to that. On page 26 of the decision, it says a court could prevent these government defendants from interfering with the platform's independent application of their policies. But without evidence of continued pressure from the defense, it appears that the platforms remain free to enforce or not to enforce those policies, even those tainted by initial governmental coercion. So it says it could prevent the government officials from doing it, but
right. You've just made all of our points.
Yeah. I look at the defendants in this case. You say that some of these folks don't even work here anymore. Well, Biden's still got a job. Murthy's still got a job. The FBI's still working. DOJ's still working. If you had a suit by the platforms and the defense was, well, okay, COVID's over, we stop leaning on you. First of all, that's not responsive to the Hunter Biden laptop and any other election misinformation, which is a recurring issue. But also it's a question of voluntary cessation as well. So,
what does that mean?
Voluntary cessation? I don't know anymore.
Well, just because the government says we've stopped doing something bad doesn't mean you necessarily moot out the case.
Right.
To the extent that misconduct can recur, then courts can still rule on whether or not it was constitutional.
And the application of that principle has been hit and miss.
Okay, so we have a dissent from Alito joined by Thomas and Gorsuch. I'm going to read two portions of that dissent. In Vullo, the alleged conduct was blunt. The federal officials' conduct here was more subtle and sophisticated. The message was delivered piecemeal by various officials over a period of time in the form of aggressive questions, complaints, insistent records requests, demands, and thinly veiled threats of potentially fatal reprisals. But the message was unmistakable, and it was duly received.
And if only we had seen that level of concern about the First Amendment from those justices in the NetChoice cases, I think the world would be a better place.
the dissent also says, what the officials did in this case was more subtle than the ham-fisted censorship found to be unconstitutional, and Vullo kind of repeating the point, but it was no less coercive, and because of the perpetrators' high positions, it was even more dangerous. It was blatantly unconstitutional, and the country may come to regret the court's failure to say so.
Maybe. I mean, ultimately, I think it's important to remember that this case, the dispute here is really about the facts. And nothing in this opinion prevents the district court from holding a hearing, having witnesses take the stand, and actually resolving some fact disputes about what happened that kind of on this record, I don't know are resolved or not. And I think ultimately that's where this case is going to come out is there a district court that finds facts, and those fact findings are entitled to deference on appeal about exactly what caused what, which I think is what's missing, and which I think if it were present would actually flip some of the votes in the majority.
Well, and that's why I'm optimistic about the results of this year's decisions on First Amendment terms. I mean, there was a trilogy of paired cases that addressed all of these various issues. The first two, the NetChoice cases that we talked about. The second, there was Vullo and Murthy that were argued the same day, although they were decided at different times. And then there were the cases involving public officials' use of social media platforms, also paired cases where there was essentially a single decision that resolved them. In all of those three scenarios, the court laid down the constitutional rules that are supposed to apply. Now, in Murthy, it didn't go ahead and apply it to these facts, but the constitutional guidelines for how lower courts are supposed to address these issues have been laid out, and they've been laid out in, I think, very speech-protective terms. And so there's still a lot of work to be done on factual records and so on. But overall, the court, I think, got it right.
Can I just ask a question that's a little bit forward-looking? Right? So in NRA v. Vullo, as we were discussing before, the regulator has an interest in regulating reputational harm. They just can't do it for ideological reasons. They can do it for reasons of financial stability and whatnot. In some of these other job-owning cases, you see state officials utilizing otherwise constitutional exercise of their authority, but for ideological reasons. So, for example, you have state attorneys generals who I believe filed suit or a complaint against Target.
They wrote a letter.
They sent him a mean letter.
An angry lawyer letter. We're well familiar with those. To Target, alleging that they violated their kind of fiduciary and shareholder responsibilities by selling merchandise that was LGBTQ themed.
Not just that. They alleged that sale of the merchandise might violate state obscenity laws, which would embarrass a first-year law student to make that kind of claim. And it even is more ironic than that. Signatories to that letter were the same attorneys general that brought the Murthy case, claiming that job owning is unconstitutional. And yet here they were the same day that decision came down, signing on to a letter threatening Target, which is why it's really important for the Supreme Court to sort this out, because the rule that it articulates will apply to those attorneys general every bit as much as it would to the Biden White House or to the officials of New York.
I also saw a story coming out of Florida recently where you had an individual place an ad that compared former President Trump to Fidel Castro, and you had a federal legislator from the state of Florida call in or write to Lamar Advertising that owns the advertising space, asking them to take it down. It just seems like, to the extent that conservatives or Republicans are concerned with job owning, that they're not actually practicing what they preach.
Well, that's an interesting example, because if all he did as a single legislator in the federal Congress was to write them and say, that crosses the line, I find that tasteless and inappropriate, you really ought to take it down. And that's all he did.
She, I believe.
Was it she? Okay.
Yeah.
All she did. Well, that's the case. That's the Twitter case in the Ninth Circuit, the Bantam Books case, where the court looked and said, okay, or was it Amazon? Was it Amazon or Twitter? I think it was Amazon. You got one legislator writing to Amazon saying you should take this, COVID debunking book out of your marketplace because it's giving people all kinds of wrong ideas. And the court said, well, this doesn't satisfy Bantam Books because this one legislator doesn't have any power over this company.
And that's why you have to look at that, the range of factors.
Right. So if that's all they did, it's a good counterpoint example.
I don't know that we do know that's all they did, because all we know is this legislator celebrated the decision and said that it came as a result of a conversation they had with Lamar Advertising. So
if you're persuasive, you're persuasive.
Right.
But if you're coercing, that's another story. And
the idea here is that as a federal legislator just representing perhaps the district, there's not only so much that they can do as a government official to affect
isn't
Lamar.
Limited to their direct authority. I mean,
it's just one factor.
It's possible for a person in a position of power to make noncompliance hurt, even if what the target of their threat, even if they are not directly at risk of having the law enforced against them. The coercion can take many forms, including informal ones.
And I think this is why you have to look at, and why I'm glad Vullo does look at things in context, because government officials wield enormous power, and limiting this doctrine to sort of the most ham-handed of threats. The most quintessential threat in the entire American lexicon is, this is a nice restaurant, it would be a shame if anything happened to it. And because those words come from someone wielding enormous power, those words are different from if I say them over dessert. And I think courts have to recognize that when government officials that wield enormous power say things like that, because I think you're right, Nico. People don't practice what they preach. People are perfectly happy to spout free speech principles and then silence speech they don't like. And honestly, I couldn't promise you that I wouldn't do that. I believe in free speech. I'm a principled person. And if you gave me infinite power, I would probably punish people who said mean things about my mother. She's a nice lady. That's why we have constitutional principles, because you have to have background rules that restrain the natural human impulse to silence people who are saying things that outrage you.
And Lord Acton meets Spider-Man.
And I'm looking through my notes right now. I think I recall something either from Murthy or Vullo, which said that, or maybe it was even Bantam Books, which said that even if the government official doesn't have the authority to make their lives miserable or to harm them, if their authority is interpreted by the entity to potentially hurt or harm them, then that can still be an unconstitutional exercise of jawboning.
To the extent there is a credible threat of some adverse action and is perceived as a threat, yes.
I want to turn now to Gonzales v. Trevino, which this is Bob McNamara's company's case.
It's an IJ case.
It's an Institute for Justice case. The case was decided on June 20th, and I will do my best to summarize it here, but I'm sure Bob will correct me on some of the facts. You have a Sylvia Gonzales, who's a resident of Castle Hills, Texas. She took office with the city council and organized a non-binding petition that called for Castle Hills, Texas's manager's removal. I believe she ran her campaign in part because of dissatisfaction with Castle Hills' city manager. After she took office, she organized a petition, again, calling for the manager's removal, and the position was presented at a city council meeting, a very contentious one, after which Mayor Edward Trevino questioned Gonzales about the location of the petition, which was found in her binder. She was then charged with some obscure Texas law, if I'm not mistaken, originally passed to prevent kind of making and usage of fake government IDs.
It's tampering with an official document. It's what you're charged with if you have a fake driver's license.
And the fact that she put this in the binder, Bob, is the tampering that they allege she engaged in?
That's what they eventually settled on. I think kind of the important thing we skipped over here is that, you know, when she, at the meeting, the petition's in her binder, she takes it out, she gives it back. She gives it back in full view of a police officer. It doesn't occur to him that she's committed any crime. Then, at the mayor's insistence, there's an investigation, at the conclusion of which the police say there's no crime here. We don't understand how this is a crime. And then a special investigator is appointed. And the special investigator, after gaining no new information, decides that actually what this is misdemeanor tampering with an official government document. He then uses a Texas procedure to walk the warrant to a judge, which keeps the warrant out of the computer system that lets you turn yourself in over the phone, which guarantees that the only way Sylvia can respond to the warrant is to go be booked in person at a jail, handcuffed and imprisoned for the day. All of which we said is pretty good evidence that this is retaliation, that this isn't because this is a crime that anyone would prosecute, but it's because Sylvia spoke out against the mayor, and so the mayor and his political cronies engineered her punishment.
So just so we're clear on the facts here, there's this petition. She submits it.
So it's unofficial. It's not like it's a petition where you get on the ballot. She was trying to show a lot of people in town don't like the city manager. And so she went door to door and had people sign a non-binding petition. And their theory was, even though it's non-binding, you submitted it to the city council. Once it's submitted to the city council, it becomes an official document. And touching it in any way, let's ignore the fact that the mayor took it home the night before, but touching it in any way is therefore a very serious crime under Texas law.
How'd she get the petition back? She go into the safe of the city council and grab it?
It was on the table in front of her.
During the city council meeting.
During the city council meeting, she picks up the papers. There's a video. The defendants in the case really love playing the video. They think it's very clear that it shows Sylvia's up to something, when in fact it shows Sylvia kind of looking at papers and putting them in her binder.
Yeah, I don't know all these papers I have in front of me, but
what would be gained by her taking the petition anyway?
That is an excellent question. I'm pretty sure there were copies of it. It's not like she brought it with her. They had it the day before. Everyone got their own copy.
I believe there were allegations that there were improprieties in how she gathered signatures and whether or not there were some duplicate signatures, and that she was gathering it to prevent the investigation of whether or not that had been improper. But whether or not that's
her non-binding citizenship.
Exactly. But the idea that the fact that she simply gathered up papers and put them in a binder while she's cleaning up her area after a city council meeting can be a crime is just astonishing.
And it can be a crime because it's a really broad statute. Like, they use it for fake driver's licenses, but it does seem to say if you take an official document and you conceal it, which when you close the binder, it's concealed, technically speaking, the statute reaches this. It's just this isn't what the statute is used for. No one in the records we could find had been prosecuted for anything.
So
it wasn't fully concealed because the mayor could still recognize it.
Yeah, it brings us back full circle to the problem of legislatures. Writing sloppy and expansive laws that can apply to anything.
Well, Fire's co-founder, Harvey Silverglate, once wrote a book called 3 Felonies a Day, which is that essentially the criminal code is so littered with laws that can be abused that any enterprising prosecutor could find 3 felonies a day that someone commits.
Right.
In this case, Sylvia argues that she would not have been charged with this had it not been for her criticism of the city and the mayor. And so she argued in court that the arrest was in retaliation for engaging in conduct protected by the First Amendment.
Well, and herein lies the problem, and it gets back to the point Bob was making about having constitutional remedies, and that is the court decided a couple of terms ago that if there were probable cause to charge you for the crime for which you are being called to answer.
So probable cause, it means she is likely to have committed, or there's
enough evidence to believe that she may have committed that crime. That probable cause cuts off the ability to file a First Amendment retaliation claim. And so the question was whether or not this case fell into one of the exceptions to that probable cause rule because, as I understand it, she did not contest the idea that there was probable cause to charge this crime, but that there was certainly sufficient evidence to show that this was really retaliation and not a good faith prosecution under that law.
That's exactly right. It's a really broad statute. It probably reaches putting a piece of paper in your binder, so we'll spot you probable cause. That's probable cause. I think I violated this broad statute. But at the same time, we have all of this other evidence that seems to show that you don't do this to anyone else, that you're doing this because you're mad at what I said about the mayor. And what the Fifth Circuit said in the case is none of that matters. They said the only exception to this probable cause rule is if you can point to someone who engaged in exactly the same conduct as you without criticizing the mayor who wasn't arrested. And in this circumstance, that's impossible. Like, no one keeps a record of every person who walked away from a city council meeting with the wrong piece of paper. We can't point you to that person, but we have all of this other evidence that we think you should look at. And the Fifth Circuit said, and to the panel's credit, it said, look, that's a sympathetic argument, and we feel for you. Our read of the Supreme Court's case law is that we have to look for the direct comparison, and since you don't have it, you don't have a claim.
So what is the outcome of this case? It was a per curiam opinion, right?
Interestingly, yes, it was.
Why is that interesting?
Well, interesting in that you don't have authorship by a particular justice. Per curiam opinions can denote broad agreement by the court.
Yeah, does it carry more weight as a result?
No.
No? Okay.
No. But just I thought it was interesting that the choice was made not to make it an authored opinion. But the upshot is that the court is backing away from the narrowness of its exception to when you can bring a retaliation claim. And it says that other evidence beyond this direct comparator evidence is sufficient. And in this case, that kind of evidence of applying a law that is never enforced against anybody can be evidence of retaliation. And so we're really a welcome change.
In Thomas's dissent, he says there is no basis in either the common law or our First Amendment precedents for the exception created in Nevis and expanded upon today. You see the court, through this term going back to Bruin, placing a significant emphasis on the text, history, and tradition of law and the Constitution. And here Thomas is falling back on that, saying there's nothing in common law, there's nothing in our history that would suggest that this exception should exist.
But talking about judicially created doctrines, I want to take issue a little bit with calling this the Nieves exception. Nieves versus Bartlett is the decision I referred to a little earlier, creating this sort of probable cause barrier to bringing a retaliation claim. And it articulated an exception saying if, let's say, someone's doing the same thing but they're not being and they're being prosecuted for jaywalking, but nobody else is being prosecuted for jaywalking, that might create a time when you can bring a retaliation claim.
Can I just give an example? So I think there was a case out of D.C. involving a pro-life group that chalked Black unborn lives matter across the street here, somewhere in D.C. They were prosecuted for that. It's either is chalking or graffiti or some sort of vandalism statute, whereas previously a group had chalked Black Lives Matter on the street and was not prosecuted. So there you have
that's a very good example where you do have a comparator. My beef with the Supreme Court is that they're referring to this as the Nieves exception based on that case, saying that there's an exception to the probable cause rule that when you have these comparators. And now in the case of Gonzales versus Trevino, you now have a somewhat broader exception. We'll find out in ensuing cases just how broad that is. But Nieves, the probable cause rule, is the exception. The constitutional rule is that the First Amendment prohibits government officials from retaliating against people because of their speech. That's the rule. Probable cause is the exception in the remedy and whether or not you can bring a claim. And so I think we should keep that we should understand that as an exception and understand that exceptions to rules and exceptions to constitutional rights need to be interpreted narrowly. So this is welcome in that it does make that exception less expansive than it previously was. But it may be a picky point to say that we shouldn't call it an exception. But I think we need to understand that the rule is that retaliation violates the First Amendment.
No, I think you're exactly right. We made that argument to the court. And I think part of the reason it ultimately was a per curiam opinion is the court seems really divided over this. Oral argument was fiery. My colleague Anya Bidwell, I think, did an extraordinary job. But the court was really focused on kind of this question. And one of the possible avenues to take here was that actually Nieves itself is just an exception to the broad First Amendment principle. And it's only for sort of on-the-spot arrests. Judge Oldham suggested this in the Fifth Circuit. And Justice Gorsuch had an extended discussion of that at oral argument where he said, look, there's a common law tort called abuse of process. And abuse of process says, sure, you had probable cause, but you did it for a bad reason. Why can't we do that under the First Amendment? Why do we need all of this Nieves stuff in this situation? And I think the court had difficulty kind of resolving some of the some of the more difficult issues in the case, which is why we saw a per curiam position that just said, yes, IJ is right, go back to the Fifth Circuit.
Well, we'll take that, right?
A win is a win.
I want to move now to Vidal v. Elster, a case decided on June 13th. And it involved an individual who wanted to register a trademark Trump too small. And under the Lanham Act, which I guess regulates how trademarks, registration of trademarks can happen, essentially says you can't register an individual's name without their permission, if I'm understanding it correctly. And the court rules here that it finds no evidence that the common law afforded protection to a person seeking a trademark of another living person's name. So it essentially holds here that you can't trademark someone else's name, regardless of whether it is pejorative or laudatory, without that person's express permission. Now, I know, Bob and Ronnie, we had filed an amicus brief in this case, arguing for a different result. Why is that?
Well, okay, so what you've had is a couple of cases, I mentioned them earlier, Tam and Brunetti in the Supreme Court, examining, the denial of trademark registrations for viewpoint-based reasons, right? They denied the slants because it disparaged a group of people. They denied fucked, F-U-C-T, because it was scandalous, immoral, whatever.
Glad you spelled that.
Well, right, because I want to be able to use the other one without violating the trademark. And so in both cases, the court said that, giving offense or, being immoral or scandalous, whatever it is, those are viewpoints, and saying you can't have a trademark registration because you've expressed those viewpoints is unconstitutional. This is a case where ultimately, now going into it, when we filed our amicus brief, the concern was this. So you've got a rule that says you can't, have a trademark that comprises the name identifying a particular living individual without their consent. And the without their consent part of it has the effect of meaning that if you use it pejoratively in some way, shape, or form, well, of course, you're not going to get consent. Whereas if you use it favorably, then you might likely well get consent, and therefore it creates another one of these viewpoint-based denials or viewpoint-based grounds on which to either grant or deny a trademark. But what the court ultimately did was it construed the provision as not being viewpoint-based. And it says this is the first time that we are called upon to review a non-viewpoint-based but content-based trademark restriction. And what do we do with that constitutionally? So that solved the problem we were most concerned about, that you were going to be allowed to be denied a trademark on the basis of viewpoint, on pejorative use of somebody's name. Once you kind of clear that hurdle, the decision kind of makes sense, although it relies again on kind of history and tradition. And I'm not in love with the frequency with which that is coming up in constitutional law. We also have and this isn't, this is going a little bit beyond our scope here, but there's a Second Amendment decision that came out this term, that turns almost entirely on history and tradition, and there are two opinions by Alito and Gorsuch that are very heavily tied into originalism. Your mileage may vary when it comes to originalism. Let's just leave that there.
Okay,
but that's one of the interesting features of this, where Vidal versus Elster was a 9-0 decision. It ultimately turned on history and tradition, and yet you see a lot of variation among the conservative justices about just how to apply these arguments and what it means to rely on historical evidence.
Can I read from Sotomayor's concurrence, which is joined by Kagan and Jackson? She writes, "I am reluctant to go further down this precipice of looking for questionable historical analogies to resolve the constitutionality of Congress's legislation. I would instead apply this court's First Amendment precedent, just as the parties did in arguing this case." So do we as First Amendment free speech advocates have a problem here if the court's going to go down this originalism road? Because we know how the First Amendment fared for the first 100-some-odd years of this country, right?
Yeah.
I mean, I don't know if we have a problem, but I do think the historical discussion in Vidal points to some problems with how the court has been applying its history and tradition test. For one thing, none of this was in the government's briefs. This isn't how the Solicitor General defended the statute. This is just that the court reached out and grabbed this.
That's what Sotomayor is referencing, yeah.
And also, the question becomes, if you're doing history and tradition, which history matters? And so the premise of Vidal is, look, trademarks never encompassed a trademark that included someone else's name. And fair enough as a historical point. That seems true. But the evidence they cite for that, suddenly there are all of these cases they're citing from the late 19th century. Yeah, and did the cases in the late 19th century change the meaning of the First Amendment? I don't know how they would do that. And the danger, I think, in history and tradition is that if you're not very careful in this is when it matters, this is the time period that matters, this is the party that has the burden of proof, you end up with what the Chief Justice once said about citing international law, which is walking into a crowded room and looking around and picking out your friends.
Yeah, and Justice Barrett made the same point in this context.
Yes. I think what the point was also made in the context of the recent Trump immunity case as well, that there was I was just listening to Advisory Opinions this morning, which is a popular podcast hosted by Sarah Isger and former Fire President David French, and they were talking about how the court is leaning into the text, history, and tradition arguments in deciding its cases, but it was almost totally absent from the Trump immunity case. I know we're not discussing the Trump immunity case, but we are discussing the consistent application of these principles to the various cases the court's deciding. And yeah, it does seem like they're inconsistent in applying it. And I do personally have a concern about applying these principles to the First Amendment context, where the history and tradition isn't always as solid as one might hope it would be.
Yeah, although if you put aside how we got there, and again, I know that's no small thing, but if you put aside how we got there, the nut of this decision is basically that, well, of course, trademark decisions are content-based. How could they be anything
yes.
but? I mean, they are a designator of origin, and to qualify, you have to be a designator of origin, you have to be non-generic, and a bunch of other things. And there's no way to determine that without looking at the content of the mark. And we know from Reed versus Gilbert that if you have to look at the content of the speech, it's a content-based regulation. So we have two choices here. Either we're going to subject every PTO decision about a trademark to strict scrutiny, or we're going to say, in this one particular area, which is inherently content-based, we're not going to do that. And that's where the court ultimately comes out here. Again, the path that it took to get there might be concerning, but I think the bottom line logic of the outcome does make some sense.
Well, and that part of Vidal, I think, may end up being the part that has the most impact outside of the trademark context, because the court does reaffirm this is the test for when a law is content-based, and obviously this law is content-based, which is an issue where a lot of appellate courts have gotten confused in recent years. So I think it's helpful to have the court essentially unanimously say, no, it's very simple to figure out if something's content-based. This is content-based. It doesn't end the inquiry here because of concerns unique to trademark.
Yeah, and it's also, you go back to the Jack Daniels case where they say the constitutional considerations don't come in until the second step of the test. The first thing you have to look at is whether it's being used as a designator of origin, or whether it's being used for purposes of parody, satire, or something else. These do kind of fit together.
Okay, I want to move now to the social media blocking cases. That's where I think we're going to wrap up. These are two cases that I think were argued on the same day and decided on the same day. That was March 15th. O'Connor-Ratcliffe v. Garnier and Lindke v. Freed. Bob, I'm going to turn it to you. What ultimately did the court decide in determining whether an individual, a government official's actions on social media to block or moderate comments or users from even seeing what they're saying on social media became state action subject to First Amendment analysis and scrutiny?
Ultimately, the court did pretty much what it did in the NetChoice cases, and that is it vacated the two decisions below, and the two decisions, as in the NetChoice cases, had gone in opposite directions. One saying it was state action for the public official to block users, the other one saying that it was not state action. And the Supreme Court said both are wrong. Here's a new test for how we are going to decide these cases going forward. We had filed amicus briefs in both of those cases and advocated upholding one and reversing the other. But the net effect of the Supreme Court's decision in articulating the new standard essentially embraced the principles that we had advocated in our amicus briefs, and that is that it is not a simple decision of whether or not the state basically controls and runs the website on behalf of the official, making it state action. You look at a range of factors. First, whether or not the official has the authority to be making statements on behalf of the state rather than on their own personal basis. But then you look at a range of factors on whether or not they are in fact using it for those official purposes. So from our standpoint, the ultimate 9-0 decision in this case was one that did lay a First Amendment groundwork that didn't create an easy way for public officials to evade constitutional responsibility when they use their personal websites for their government jobs.
So let's say you have a government official who has a Facebook page, and on it they're posting about their birthday, their kids' birthdays, their wedding anniversary, lots of personal stuff, but they're also opining on things they're doing in their capacity as a city council member, for example.
That's exactly what was happening in these cases. You had people who were using their personal pages that had started as personal pages, but then when they became public officials, they essentially used it in conjunction with all the personal stuff they posted and also used it for official business. Now, you can dispute those facts below, but that's essentially the allegation of what was going on. And in one case, you had a city manager who was doing that. In another case, you had a school board member. And so these were really stand-ins for the real question, which had been presented with former President Trump's use of his Twitter account.
Yeah, I was going to ask about that.
Right. That's where this case started. And you had lower courts at least deciding that the way in which the former president was using Twitter was essentially to create a public forum. He was using it for official purposes. He was having government employees manage it for him. He was doing all of this stuff. And the lower court said, well, if you look at the use and appearance of the website, all of these factors say that this really is a form of state action, and you can't just arbitrarily cancel users and delete comments from your critics. You have to accept the obligations of a public forum once you've opened one. That case was going to be reviewed by the Supreme Court, but when President Trump left office, that case was mooted. So these cases were accepted in tandem, like the others I'd mentioned before, to decide that basic question. And the reason it's important is that the use of personal pages for official business is endemic at all levels of government. You have people who have official pages for their offices. They may use them, they may not, but they may, and many do, conduct most of their business on their personal pages. Members of Congress do it. Certainly President Trump had used his personal page that way. And in this case, these two cases, the Supreme Court confronted lower-level officials that did that. So the question becomes, when can public officials become responsible as state actors? When are they acting under color of state law to essentially use their personal pages as a public forum?
So social media companies or platforms shouldn't be common carriers, but they can be public forums?
Well, the comment section, when a state official using it for official purposes opens it for comments of third parties, the state official has created a public forum, not the social media company.
That's right. And the decisions were clear that that wasn't what this was about. It wasn't converting Twitter writ large as a public forum. It was the particular account being used for government purposes that was considered to be a forum.
And I think it's important, like, this is not a question. It arises in the context of social media because it makes it easier for all of us to create a public forum, but it's not a question unique to social media. If there's a lecture hall in my town and I have rented it out every Monday night, I just have a standing date, and then I'm elected mayor, I don't lose the right to have my standing date in the lecture hall just because I was elected mayor. But if I start using my standing date to host the city council meetings, then I'm probably going to be obligated to allow people to speak out at the city council meetings, none of which deprives the lecture hall itself from its property right in owning its lecture hall. I just happen to have leased that, and then I have used it in my capacity as mayor to host the city council meetings.
And it goes beyond that because, it's not just a question of whether you've opened a forum or not. I mean, when it comes to your use of social media, it can be implicated in even things like open records laws, right? The question is, are you using your personal cell phone? Are you using your personal social media account for conducting government business? If you are, then you're creating public records with it. We had a case with the mayor of Detroit some years back. The whole question was whether his text messages were recoverable under open records law, and the ultimate issue was he using it for official business? This test has applications beyond just the comment sections.
Do the social media companies have any requirements under this reasoning? Like, for example, are they now required to remove the ability for public officials to moderate?
No.
So it's all the entire burden, the responsibility lies with the public official who uses these private means to
just like the guys who own the lecture hall don't have to send their flunkies to make the open the door to city council meetings. It's a duty that would run to me.
And there's
public
an
officials do this volitionally, right? Nothing requires them to use their personal accounts for public business. And it's only those that have chosen to that then run the risk that it's going to be found to be subject to constitutional obligations.
And there's an admonition at the end of the majority decision specifically about those kinds of mixed uses that you may be forfeiting the ability to exclude if you do so.
Yeah, and by the way, any public official can have their personal account. This doesn't affect that whatsoever. They can run their campaign using their personal social media. Being a candidate doesn't make you a public official, even if you're currently holding office. That is private speech that is constitutionally protected in its own right. But once you are an official, using your personal social media account for public business, then you run the risk of these constitutional obligations kicking in.
Can I just ask, we've covered the cases we need to cover, but I want to ask, because I imagine some of our listeners will write to me about this, the Chevron case overturns Chevron deference. This is the deference that's given to administrative agencies in implementing laws where the sort of requirements are unclear. Any First Amendment implications from this?
Absolutely. And
very quick on the jump there, Bob.
End of the podcast.
Well, because you hear all of these sort of apocalyptic descriptions of the decision saying, oh my God, the expert agencies protecting the environment, the EPA, are going to be hobbled, and you're going to put federal court judges as czars over the administrative state. But keep in mind that these were all ways in which you were expanding agency power at the expense of the rule of law, essentially, oversight by the courts as to what legislation actually means. I think deferring to an agency's interpretation really makes very little sense when you have courts that are charged with that very function of deciding what the law means. And the First Amendment implications come because I used to work at the FCC, and that kind of administrative deference was something that agencies that regulate speech day in and day out count on. They count on courts giving them the benefit of the doubt when they are interpreting how far they may go in regulating speech. We saw this constantly in the cases over broadcast indecency, where the agency would argue in every case that the court must defer to it. Well, two things about that. One is agencies have no special expertise when it comes to interpreting the statutes under which they operate. Courts do. And the other is there are constitutional issues here involved as well. And the agencies, being agencies, would always push that boundary and say the court should defer to them on constitutional questions as well. And again, that is really getting the law wrong. And so the removal of Chevron deference will be a net positive for free speech when it comes to deference to lack of deference, no longer deferring to administrative agencies that have the power to regulate speech.
Let me ask you a quick question for Bob. Were you at the FCC before Chevron and after Chevron? Like, did you see how it might have changed your
Chevron
analysis?
was decided in 1984. I went to the FCC in 1989.
I see. I'd be really interested to hear how it might have changed how agencies approach things within the agency.
I mean,
I did not.
In a perfect world, this would be a net because in theory, courts getting agency decisions that implicate constitutional questions, especially First Amendment questions, should be conducting de novo review of the record. They should be interpreting statutes in a way that renders them constitutional. It should be interpreting regs in ways that render them constitutional. Now, the problem, as Bob outlined it, was that the courts didn't always do that because Chevron led them to give more deference than they should. So it will be a net positive. It'll put the courts back into doing it the right way.
Well, and if it works as we hope it will, it may force Congress to be more clear when it creates statutory mandates.
Bob, did you have anything else you wanted to add on this
I
one?
concur with my learned colleagues.
Very good. Hey, Ronnie, we got some news just before we jumped into this studio. Do you want to give our listeners an update on that?
Yeah, I mean, there was a petition for cert on the decision out of, wait for it, the Fifth Circuit, where there's an age verification for adult content law that many, they've been coming up in other states. They've been getting challenged. They've been mostly getting struck down. Indiana just most recently last week. Somehow the Fifth Circuit, despite Reno, almost 30 years ago.
Despite 4 different cases that established.
The oldest being Reno, somehow managed to find age verification constitutional under a analysis that, well, let's just leave it as saying it left things to be desired. In any event, the court this morning granted the petition for certiorari of the Free Speech Coalition to review that case, and we'll be looking forward to seeing it take it up next term.
And we discussed age verification on this podcast during the last episode. So if you haven't checked that one out, please do. I think we're going to leave it there, folks. That was Fire General Counsel Ronnie London. Ronnie, welcome. Thank you. Welcome. Are we starting this podcast over again?
Okay.
Ronnie, thanks for coming on the show. We also have Fire Chief Counsel Bob Corn-Revere and Institute for Justice Deputy Litigation Director Bob McNamara. I am Nico Perino, and this podcast is recorded and edited by a rotating roster of my Fire colleagues, including Aaron Reese and Chris Maltby. To learn more about So to Speak, you can subscribe to our YouTube channel or Substack page, both of which feature video versions of this conversation. We're also on X by searching for the handle Free Speech Talk, and on Facebook. If you have feedback on the show or any questions you'd like me to bring up on future episodes, you can send that feedback to sotospeak@thefire.org. Again, that's sotospeak@thefire.org. And if you enjoyed this episode, please consider leaving us a review on Apple Podcasts, Google Play, Spotify, wherever you get your podcast. Reviews help us attract new listeners to the show. And until next time, thanks again for listening.